here this evening. Thanks.
Thank you, Council. So if I hear that correctly, the motion then would be to allow release from the conditional use grants of 18 of the 19 with the exclusion of 7G.
7G in the 2008 grant. That's correct, Mayor.
2008 grant. And Mr. Harris, do we know, I mean, has that area ever been soil tested? Have they ever soil bored out there for fly ash or anything else that would have come up in the nearly 100 years that plant's been there?
Not to my knowledge.
Okay, but the We Energies doesn't, okay.
They have no, according to Mr. Berkey, today they have no indication that there was any substances that were buried or placed upon that property during the time they've owned it. And Mayor, if I could just append your summary of the motion could also include, as to that item 7G, that could be released upon a separate agreement being entered into between the city and WEPCO or We Energies, providing for a separate environmental indemnification. Thank you.
Okay. But as far as we're concerned, then, for us to move it up to council, then our motion would be to release them and then leave in the 7G, the 2008. And then what I guess I would request is in the suggested motion at the council level that we include that language. If you guys wouldn't mind writing that out then for that.
Yes.
So that, Mr. Harris, so in your executive summary to council, then that would include that motion language properly.
That is correct.
Okay. All right, any questions? Yeah, go ahead. Alderman Neumeyer?
Sorry, a little bit off the record. I talked to Mr. Harris earlier. Since I'm sort of the historian on this council, I've been around so long. When we were engaged with We Energies, and prior to my getting on council, when the power plant went in, the intention was always to have public access to the beach all the way south. And I'm going to dig in on that when we get farther down the line, that we insist on public access to that beach, that it be cut off when we have clay banks coming up. That was always to have access from our South Beach down. So if we can engage the current or future property owners on that, I would like to see that, please.
Has that been platted, Mr. Harris? These properties to the south that are we're releasing?
I mean, they're parcels with tax keys, and so they are platted,
way.
identified parcels.
Okay, but not as far as like what the property lines would be for development there?
No, not for.
I'm trying to get to Mr. Neumeyer's question. I mean, no one can own the beach. They can't block it off or make it private, if I'm not mistaken, on the Great Lakes.
On the public use doctrine.
Go ahead.
Go ahead, Council.
Thank you. Well, there's the old adage, long-standing in Wisconsin law, that says the public has right to up to the ordinary high water mark of the body of water, in this case, Lake Michigan. So to state that differently, as long as members of the public were to keep their feet wet while traversing the shoreline, that would be perfectly legal. But beyond that, if the developer, the purchaser and developer, presumably of these two parcels, in the course of development discussions with the city, were to set aside some additional public access rights, that's certainly something that could be discussed. But the state of the law is that the public would have access and use only up to the ordinary high water mark, that is, while they're keeping their feet wet, figuratively speaking.
Water bottles. Okay. Thank you. Mr. Knoop?
As part of the added language for the Common Council review, would we want to include environmental testing as part of that? I mean, right now, it's rather notional that it may or may not have anything. Should we quantify that by having We Energies test that?
If I may, thank you, Mayor. Mr. Berkey said that while our conversation doesn't reflect the last word and his binding authority, he felt very comfortable by his comments that the We Energies would extend that indemnification as to those two parcels. So whether or not something is there, if We Energies signs and binds itself to that sort of indemnification provision, then whether or not something is there, WEPCO would be responsible for remediating it.
So if the next property owner were to do soil borings, find something, the city of Port Washington is not legally responsible. It stays with We Energies or WEPCO, correct?
That is correct. Or the new owner in the chain of title, they would bear some responsibility as a potentially responsible party as well.
Okay.
But that would only be if item 7G remains in there.
Well, in the sale of in allowing them out, and then if they were to sell the property, the indemnification clause, if I'm hearing this correctly, We Energies would be out of that, and the next property owner would be liable for whatever was there. This is keeping the city out of it along the way.
The We Energy, just to be clear, the We Energies or WEPCO entity and the city would have a separate freestanding agreement that would protect the city's interests environmentally as to those two parcels, yes.
Well, I'll make a motion then to take the staff recommendation to release, to allow the conditional use grant release with the exception of 7G in the 2008 conditional use grant.
I'll second.
Seconded by Commissioner Ryer. Any questions or concerns on the motion? All right, seeing none, all in favor signify by saying aye.
Aye.
Opposed? All right. The only thing, Bob, or Mr. Harris, if we could, again, in the council packet, if you could just ensure that the correct motion, suggested motion is in there that includes all of that language, that'd be great. All right, that takes us to item number 5, municipal code recodification. This is a review and recommendation regarding the adoption of proposed revisions to and codifications of portions of new code of the city of Port Washington relating to subdivision regulations, zoning, extraterritorial zoning, extraterritorial plat approval, fire safety code, and any other matters over which the Plan Commission has jurisdiction or exercises responsibility pursuant to the Wisconsin state statutes or municipal code of the city of Port Washington. Basically, the background on this is that we have not really done this for quite a while, and it's time for us to exclude all blue laws that are on the books, as well as grammar issues, ambiguities, minor substantive changes, as well as non-controversial issues due to changes in federal or state laws. And that brings us to Mr. Harris with the recommendation that we continue through the vetting, that the staff recommends the approval of the proposed recodification ordinance as it's written. So, Mr. Harris, and then Mr. Eberhardt.
Okay, well, this, as stated, this is a recodification of the municipal code. This has been undertaken by both the city attorney and the city clerk for several years now. And portions of that code do require a recommendation from the council to the Plan Commission as identified in the memo. And the schedule, both the copy of the ordinance that would approve the recodification and the schedule of changes that are before the Plan Commission are included in the packet. And I don't think I have much to say, given that it's just this has been undertaken by largely the city attorney. And I think I'll just turn it over to him to explain what exactly was is the endeavor here and what we are recommending here.
All right, Mr. Eberhardt.
Thank you, Mayor. Yes, Bob is correct. The process of recodification has been long and arduous, and this is the first step, however, in wrapping that up from a legal procedural standpoint. I think that the city planner's memo is a pretty good overview of how we got here, so to speak. I want to add and emphasize, frankly, the assistance of the city clerk and of the city's editor assigned to this matter through the General Code Company out of New York. That company has done recodifications, I've learned in this process, for more than 60 years, for over 4,000 local government units in 44 states. So they have a tremendous breadth and depth of knowledge about all such matters, and in the case of our assigned editor, extensive knowledge about Wisconsin law, although she is herself not an attorney. She was a great source of information and advice to me, for which I thank them. The mayor is correct that the well-understood purposes of recodification periodically is basically to clean up obsolete or outdated references, to identify and fix conflicts and inconsistencies in local ordinances, both with state and federal law and rules and regulations. It's beyond just typographical errors. It goes into restructuring, reorganizing, relocating, renumbering entire code sections and chapters to make them a more unified and coherent whole, to update stylistically the language of our ordinances, to modernize them, to supply any omissions, to use terminology consistently throughout our code, and again, with the end goal of making our ordinances more easily understood, not just to city clerks and to city attorneys, but to the public in general, to developers and other users. And I think that we are well on the way to finalizing that this time around. For those of you interested in historical matters, this code supposedly was last updated in 1984. However, the city clerk was able to dip into the archives to find that, yes, in 1984, the city code of the municipal code of the city of Port Washington was recodified, but only to renumber it. Only to put in play a new numbering scheme. There were no substantive changes at that time. And so we did not, the city clerk, and I look back to see how long before that the code might have been, codified, but I suspect it was a long, long time ago. 1984 was, of course, 39 years ago, but this has really been an exhaustive, comprehensive effort, if there ever was one. So you have, and included in your agenda materials was Schedule A, and as the city planner told you, it represents sort of a one-stop shopping place of reference for the various changes that have been suggested and hopefully will be implemented. The city planner emphasized those that are within the jurisdiction or purview of this body, obviously zoning being chief among them. I hope you've had a chance to look at those. I can tell you, as I alluded to earlier, that this meeting is sort of the first of several steps, which will culminate on July 18th, hopefully, with the council's adoption of the new code. And even after that, for a period of time, pursuant to the Wisconsin statutes, the new code will have to be published in some form, but also made available to the public both before and after its adoption for their review. There are some practical considerations anytime a municipal code is recodified. I don't think, though, that those are pertinent to this body, and so I won't delve into those now. I'd be happy to entertain any questions you might have about the process, and I want to emphasize in closing that while the recodification process for a period of time sort of morphed into a deep, long look at changing substantive provisions, indeed rewriting whole sections or chapters. In the end, the city clerk and I, and with the guidance of the city administrators, past and present, decided that that was not the proper focus or scope of recodification. So thanks to them, we were able to get that back on track, and I appreciate your patience, and I would be happy to entertain any questions.
Mr. Harris, what were you doing today in 1984?
It was summer of going into my junior year
Excellent.
of high school.
Mr. Ryer?
That was 3.
There we go. We're going to stop right there. Okay. So with the recodification code, I appreciate the diligence on this, and I do want, the city, as part of our strategic plan, this was a significant conversation in there, and now knowing that it's been since 1984, I think it's pretty important. This will become a regular rotation now of review in the shorter term. It's on a 5 and 10-year review plan. For instance, on page 19, my favorite one is that for taxi cabs, there's a doctor's certificate is required, and all taxi drivers will wear a cap at all times while operating a taxi cab with the name of the owner of said taxi legibly printed thereon. I think the last taxi cab driver I remember was Port Taxi was Alice. because my mom was the dispatcher. And that was way before 1984. And I don't remember her wearing a hat when she picked me up from violin lessons. So I appreciate that, because as you go through the code specifically around zoning, it's not that far off, but the requirements and shifts for statutory alignment is very, very important for us, because we can be held liable to whatever's on our books. So any other questions or concerns there? Mr. Knoop?
Yeah, I would have a question for council, and that would be, in the 1984 renumbering, or I should go back, with the material that was provided to us, we were given a lot of numbers here of chapters that do not align with the municipal code that we have on our website. So any level of attempt by anyone on this committee to cross-reference any of these, to check them out, was near impossible. Were these numbers that were in here, chapter 404, chapter 415, was that all part of that original code?
No, in a word, no. There is a what's called a derivation table, which shows the provisions of the 1984 code, and as they are renumbered by the editor, that was not a child of the city clerk or myself in terms of the process. We did not assign new sections or numbers. That's what the editor does. So there's a derivation table and also what's called a disposition list, which is different and which shows how ordinances adopted by the city since 2015 have been located and placed within the larger new code, the 2023 code.
As part of the process, all sections will be will be in alignment, is my understanding.
Okay, so I guess then the big part of my question here is, this committee is expected to review this, to make a recommendation to council that we feel that this is an appropriate recodification of our municipal code, but we have virtually no ability without this derivation table to see the items that Bob highlighted. I can't just go and check those out and look at it and, well, what are we eliminating, and is it in context with what we want to? Was that the expectation for the Plan Commission, to,
Go that deep?
we should just stamp it and move it through?
No, it's not, well, not said like that, but taking the staff recommendation after legal review, yeah, we would approve their legal review of that and the alignment of it.
Okay, so then with that, there were a number of the 2 hours of time that I put in to get through about 4 pages of this, translating it back to our municipal code. There are certain areas here where we're changing language and we're calling it out in one spot, but then in my research with this, I found 3 other references to it. So then, if we make this approval, does that not, do we change it in the one instance?
So I think what we would do in that case, Kyle, is that you would give that to council before it goes to you'd give it to our legal counsel, whatever those different pieces are, for them to line up before the city council gets it.
But you just said that isn't our responsibility to go this deep into this.
No, it's their responsibility to do the diligence so that we wouldn't have to. So I guess what I'm saying is, if you have found where it's ping-ponging within our own documents, that they should get that feedback so they can fix it before the city council gets it.
Okay. And I've only, without any kind of table to find out where chapter 4042 is actually chapter 12.06B. I've got 4 pages of this entire document.
Yeah.
I'm just confused with what our responsibility is here, and
Yeah.
seeing some gaps here, I've got concerns about just approving this.
Okay, so a couple of things. One, I'm unaware of any instances in which one term is defined one way or one person assigned responsibilities referred to by one title and then elsewhere otherwise. Unaware of that. If you have those, I would be interested in seeing those. But I'm unaware of any, and the city clerk likewise is unaware of any, and the editor is likewise unaware of any. The primary responsibility falls to the editor, and they have very extensive and powerful, impressive, frankly, word processing computer software that enables them to do the great job that they do. In terms of the scope of this body's responsibility legally, it is not to delve into substance. It is to, and I would also say in my reading of the portions of Schedule A that pertain to this body's area of jurisdiction legally, that I think it's rather clear, not in every case, but in many or most cases, what it is that is being referred to, without having to go in and delve into it, because the substantive, that frankly is not also not the role of the Common Council in a recodification, is to rewrite substantively portions of the code. It is to carry forward the technical corrections that I spoke about earlier. That's my response.
So you can take a look at what he found and
Yes.
what those differences
I
are?
certainly will.
Any other questions?
And that one's down too.
I'd ask you to explain those to him, because if our experts didn't find it, I don't want to create a. All right, is there anyone willing to make a motion to move this on to city council then?
So moved.
Moved by Alderman Newmeyer, is there a second?
I will second.
Second by Commissioner Ryer. Any questions or concerns on the motion? Okay, seeing none, all in favor signify by saying aye.
Aye.
Opposed?
Nate?
Passes 3-1. Okay, that's it. I'd look for a motion to adjourn.
So moved.
All right, moved by Alderman Newmeyer, second by Mr. Ryer. All in favor signify by saying aye.
Aye.
Opposed? All right, excellent. This meeting is adjourned. Good night, everybody.